Recently, I was approached by a businessman not based on the West Coast who was flustered by a case that's currently pending in New York and was asking me, why can't we get in front of the court pretty much right out of the gate that this case should be dismissed? This agreement, this non-compete agreement that these young people are being, at least for the time being held to, should be declared unenforceable as a matter of law because ultimately it'll prevent them from being able to earn a meaningful living. And what I was forced to explain to this gentleman is that there's a fundamental distinction between California law, where he's based on this subject, relative to New York law. California Business and Professions Code section 16,600 states that, quote, except as provided in this chapter, every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void, which means pretty much out of the gate, a non-compete agreement on its face may be declared invalid as a matter of law. On the other hand, under New York law, the Court of Appeals has held, and that's the highest state court in New York, in the seminal case of BDO Seidman v. Hirschberg, which is a 1999 case, that there's a prevailing standard of reasonableness in determining the validity of employee agreements not to compete. In this context, a restrictive covenant will only be subject to specific enforcement to the extent that it is reasonable in time and area, necessary to protect the employer's legitimate interests, not harmful to the general public, and not unreasonably burdensome to the employee. Which means, as a practical matter, the court is going to have to engage in some type of a balancing test between the interests of the employee who's looking to move on in his career on the one hand, and the legitimate interests of the former employer in making sure that their turf is protected within reasonable bounds. And that's why the court is not likely under New York law to just take a look at it on its face and make a snap judgment as to whether or not the agreement is enforceable. Thank you very much for listening to this. And if you have any further questions on the distinctions between California and New York law regarding non-competes, please feel free to pick up the phone and give me a call. My number is 516-791-5700. This is Jonathan Cooper, and have a great rest of the day.